Good afternoon.
Afternoon, Archie.
How are you?
Good and you?
Oh, I'm fine.
It's
I
good.
said, oh, my eager beavers are here and ready to go.
That's only because
That's only because of.
I got a bird. I have the technician care service in my AC.
Oh, so you're in a really good mood then.
Mm.
But after you service it, I will. Because
Yes, you'll be cool.
yes, yes,
All right. So you'll be in a good place.
yes.
That only means you could study more.
Mm.
Miss Anja. No.
You'll see.
As I've been reading, I realized there's a lot of information.
Oh,
Yeah.
Lord. We're going to narrow it down. Remember, I told you could start reading, but today I will tell you where the exam will be focusing. Did I not say that?
You did,
Yeah.
yes, ma'am.
Yes. I say don't study, just read.
Yes.
So when I tell you, then you would see. And we've covered a lot of material, and a lot of it we have discussed.
Yeah.
We've done a lot of questions in class. And based on the questions in class, I would say those areas you all know very well. You are always prepared for class. And so my final exam is not focused on those areas that you know.
Okay. While you're at it, can you take one of those questions of a capstone?
What? Hold on. Let me do my exam stuff first, and then we can discuss capstone at the end.
Okay.
That's fine.
Before you go, you should see me rowing on the second question. I say, boy, it's a difference because when I read it initially, I didn't know as much as I knew after reading maybe chapter 6 and 7. And then I saw what the directors were doing. I say, oh no, they can't do that. Oh no, they can't do that.
But at first you were kind of lost, right?
Yeah, I was lost. And then I was teed off at the end.
Hello.
Hi.
Hey, GL.
Yes, yeah. Continue talking.
Yeah, so now I know some things. I said that's the difference between you going into a situation, knowing something, and then going into something not knowing anything. So now I know teams. I know, oh no, they can't do that. I have to fight the big resolution for them.
Right. So right. So what I have observed from the class is, one, you paid attention to the act itself, whichever one you focused on. You all paid attention to the act. You all learned how to apply it to situations. I would mention cases. I sent you cases, and what I was pleased about is that you all didn't get the cases and just throw it down. You all were interested in knowing what it said and how to apply it to issues. And that's what you get out of company law. You can't just read the notes in the manual and say, oh my God, what this is, I don't understand. You have to apply it. Once you apply it, then you begin to see, okay, that's how this works. But if you don't immerse yourself in this, by the time the course is over, you will still be lost. And it takes a lot. Yeah. But you'll see now that the day is the last day, you will see that you've really learned a lot. And there's even much more you could learn just in this part of the topic of company law. Because there's a lot more to company law than just what we covered.
That's right.
Yeah, because there are a lot of cases, a lot of issues, like any topic. But it is really interesting, company law. Yeah. And I could say that you all who have actually stayed and hang till the very end, you appreciate it now more than ever before. Than when you first started complaining, oh, I'm not doing this. Too many cases. Case again. Which
Yeah.
Companies Act, IBC Act? What? We must know these sections. Why? Why? Okay. And now you see, even looking at the Bahamian cases, when it comes up, you begin to see how important it is to know at least something about a company and how it operates.
Yeah.
That's the benefit of taking this class. But I mean, if you would actually work in a corporate office, you'll see there's even more in terms of the filing requirements and all those kind of stuff and the wording of different things. But all that comes from practice. But you have to have that basic knowledge of a company and what it means and how it operates and what it can and cannot do. And you'll be surprised how many people don't know what is the actual framework that governs a company. That is not just the memo and arts. There's also the act under which it was incorporated. And then you have the case law. So now you've had an opportunity to actually read this and understand it. And now you found it to be exciting.
Yeah, I want to be honest with you. I find the cases more interesting than the actual thing. But in order to understand what's going on in the cases, you need to know the law part of it. So
Mhm.
because even with the human rights stuff, I didn't realize there were so many cases with human rights and companies violating human rights.
Yes,
Mhm.
yes.
Just in terms of, I found one in particular with Shell in Africa, I believe it was. I can't remember which country in Africa. They had supplied the rival tribe with weapons this particular tribe had, they were located in a place where oil was, and Shell wanted the land, but obviously they didn't want to move, so they supplied another rival tribe with weapons to kind of drive them out, and they almost wiped out the whole tribe, but they were able to get on. But now when people started getting arrested and started singing, because I didn't want to go to jail, now you realize, hey, Shell name popping up a lot here.
Mhm.
Because remember, I told you at the beginning of class, right? Remember the beginning of class, I began to tell you that is now a new element in company law, human rights violation.
Yeah.
And it's really becoming a hot topic. So that is why I had put it on the paper so you could be enlightened and informed. And you could see that this whole thing about company law has in its own personality, like a human, everything affects it.
Yeah. Yeah, but I was like, people so dirty, man. Why you can't just acquire the land? But see, you couldn't tie back until you started getting arrested because there was no paper trail. They just bought the weapons. So I don't know how they did that under the table, but you know, in countries like that and third world countries, it's easy to pay people off.
Yes.
So they were able to get for a while.
Right. But what is also surprising to see that the things that these big international companies do to get what they want.
Yeah.
And they do it. Now, only because they're now bringing up all of these human rights violations. Remember, I told you they have had like a lot of, like the spill off from when they're drilling for oil, all that sludge.
Yeah.
All of that went into the rivers. And the persons in those villages, they fish in there, they bathe in there, and they wash their clothes, and they were not cleaning it up. And those people got cancer. And they would not pay. They had to be sued.
Yeah.
So they would tell their head office that they paid a company to clean it up, but it was never cleaned.
I think what company was that? Exxon.
Yeah.
They had two major oil spills over the last, I think, 40 years. the first one, they are still finding oil deposits from, even now, some 30, 50 years later, they're still finding oil deposits from that first spill. And then they had the Deepwater Horizon oil spills. That didn't
Mhm.
particularly, that was more fall down of the internal procedures, not really.
Yeah,
helping.
yeah.
Yeah, but, that was
Net-
interesting too.
Yeah, that was Deep Horizons. That was a good one. Netflix has one of those African films, but oil spills. I can't remember the name, but Netflix has one too.
Okay, I'll look that up.
Yeah, and it's talking about how the oil people are still using the water in the river and they're getting sick.
Wow.
Yeah, I can't remember the name of it, but I watched it. It was a good one, a really good one. Yeah, but I'm glad that you all took a deep dive into the class and you began to apply it and you began to appreciate, the beauty of company law. So
Yes.
now, the first thing I have to talk about is the Chisholm matter.
Mm,
2 Chisholm cases,
yeah.
Supreme Court and Court of Appeals. Okay, so in this matter, these 2 individuals got married. They were married for over 20 years. Prior to the husband's marriage, he was married before he had children, and he put the assets that belonged to him and his first wife in a company, with him only owning 5% interest, the rest to his children. Now, what he did wrong was that when he got married, he told his wife, 1, stop working,
Mhm.
right? And he's so stupid. He then put her in charge of all
Right.
the assets that were in the company.
So she was able to see all the teeth.
She managed them.
Mhm.
She managed the companies. She helped the companies to grow. She helped to make decisions.
Right.
So her argument was that, yes, you put the assets in there. You say you only own 5%, which he did not prove to the court,
Mhm.
because you could not own 5%, have a 5% interest in a company, right? But all of these
Police
assets,
assets.
but you let your second wife manage all the assets and made decisions on those assets. And then divorce her and give her nothing.
Yeah, that's wrong.
So even though he put the assets in a company law did not even come into play. Because as far as the court was concerned, he was not fair. See, again, he was stupid. The court gave him an order and asked him to produce statements for all of his balances of all of his accounts, and he didn't do it.
No.
He
But his
did not
attorney should have
produce a
advised him.
statement. Well, he probably say he's not doing it.
Mhm.
And a
Yeah.
man at this age,
Uh-huh.
where is he going?
70-something years
At
old.
this age, this man is old.
Yeah.
His wife is sick. She had back surgery.
Diabetic. She's
Diabetic.
diabetic.
And
Mhm.
yeah. And you putting this old woman out with no
Mhm.
roof over her head. You take all the jewelry you gave to her, and
Mhm.
you're a pastor of a church.
Ah, greedy.
No,
Yeah.
no. And that's why
Did
the
they-
Court of Appeal says that decision by the judge was
Mhm.
fair.
That's right.
It was fair. You
Did they-
cannot do that.
I agree with them.
What you going to say?
Did they say why they were getting a divorce? I'm sorry.
No.
It didn't say.
Okay.
No, that wouldn't have been, that would no. This matter has to do with when it was time now to distribute the assets. That would have
Okay.
been the court matter before this.
Okay,
So it only could have been on one of the three grounds: desertion or cruelty. So I don't know which one it is that he would have tried to say was the reason why he wanted a divorce. I don't remember him saying he was cruel. Was he cruel?
I don't remember.
How you divorce him?
Did I?
Why did you divorce him at that age?
70 something. They should be together, praising God.
you mean how he finds someone younger?
That's
I
maybe
mean-
true, Blair.
If
Well,
he, had,
anything.
he had money, like you say, he had money. He surely found someone younger.
Yeah, when he coming out every hole. This man has so much things. Oh,
Yeah.
And seriously, he had a lot of money.
yes. And then they even turned one of the duplexes in South Beach into like a dwelling home for them and put the other one on
Uh-huh.
rent. Like,
Wow.
Right. So it only could have been one of one. I say three, and the other one would have been oh Lord,
adultery.
adultery.
No. Mm.
No, adultery. It's either adultery or cruelty.
Mhm.
One of those two.
You said a desertion too?
Yeah, desertion is the third one, but he
Desertion,
didn't
yeah,
deserve
okay.
her.
No, okay.
Yeah. So it's either cruelty or adultery. So I'm leaning more towards adultery.
Me too. Find an
Yeah.
exorcist in the church.
Yeah, he found an exorcist in the church. And guess what? He was gonna follow the same pattern again.
Yeah.
Because
That's
this
it.
woman, go ahead.
Mm-hmm. But Miss Archer, you think that his children can't say, well, Dad, you have to give us something?
No. You
Why
missed
and
that
they want
line.
to
She said things turned for the worse when the children started interfering in their marriage.
Wow.
Oh, that was in the
So-
one, the Supreme Court one you read it.
I read it too.
Oh,
I can't
okay.
tell you it. I read both of them.
Okay.
But
okay.
the funny thing was this. He put the assets in the company name for him and the children because that came from the first wife. He should have
Mhm.
allowed the children to run those businesses.
Mhm.
Now, Miss Ann, you know better than that. Them children will spend money.
Yeah,
Mhm.
but see, and the thing about it is they spending money, and when they see this woman had some good business head and they really was making money,
Yeah.
then they started to get in. Daddy, I hope you hope this woman think this woman ain't getting none of this money
Yeah,
yet.
that's money. Yes.
But she
But
was
what
the
he-
brain. She was the brain behind it.
Mhm.
But he should have just made sure she was straight. I'm sure
That's
she
it.
wouldn't have a problem if
As far
she,
as don't
he
forget
made-
now, think about it. This man is already in his mind, he's old school. So he
Mhm.
already thinking that his mass of wealth that he got was made between him and his first wife,
yeah.
right? So I'm hiring you now. I'm marrying you now as my second wife. And like she said, she did her wifely duties. She had sex. She cooked.
Yeah.
Yeah.
Yes.
Yep.
She let you know.
What she
Yep.
did, yeah. Yeah. But,
Uh-huh.
but Miss Archer, do you think that
At
she was a
70 something,
foreigner?
why did we having sex at 70 something? What is that? That is gross.
Right? You stay right there. You could be just like that.
70 something? Oh God, no.
You will be right there.
No,
Yeah.
that don't make no sense. What you was gonna say?
I was saying, you think she's a Bahamian? You think
Her
not.
maiden name, no. Her maiden
But
name is
that may be a factor
Big
too.
Bateman.
That may be a factor too.
Yeah, I don't know that name.
Yeah, I don't know the name either.
That doesn't sound familiar at all.
They may say, oh,
Wow.
she from somewhere else. She gonna take all the daddy money and carry it back when she get all of
Well, I don't
people
know
think.
this. I don't know this church.
You see, I don't want children getting the man business. Because furthermore, I ain't dead. And I still could change my mind whether I leaving it to you or not. So stay out of my business. That's the first thing.
Yeah,
Second,
dear.
Mm.
you gotta make sure your current wife, was straight. Especially how you asking on the work. she should have had a separate account. You was dumping some money in for her so she could be okay after you leave. A
That's
house
right.
that-
But he had all those bank accounts. He had a lot of bank accounts.
Wasn't there an accusation of theft at some point through all of it? That she
Yeah.
was taking money from something?
No.
No,
Uh-uh.
I remember that.
I think I was reading something else then.
Mm-mm. Now, don't forget now, in the actual court hearings, he referred to a lot of cases that he says was similar to,
Yeah,
right? But in her mind, this woman, this Ophelia, no, she didn't say that. But he's
This
adamant.
part here, okay, this part here from the Court of Appeal. See, because I was scribbling up through this while I was reading and trying to
Okay, go ahead.
understand certain things. There was failure to fully consider or at all the allegations by the petitioner that there was a siphoning of company proceeds on part of the respondents for 5 years, 5 to 6 years of the marriage.
Where this is?
This
What
page
paragraph?
9 of the
Court of
Court of
Appeal?
Appeal thing, yeah.
Hold on, did I read that?
I must have skipped that too, because I ain't remember that.
Yeah. Let me see.
Which number, JL?
You say page
18.
9?
Yeah,
18?
page 9, this says 18.6.
I see it.
The company proceeds on.
Was there a thing in the previous,
No, because I read further where the judge was saying that he brought matters into the Court of Appeals that were not discussed at the lower court.
Mhm.
see?
Yeah, the judge did not discuss this.
Would you see it? That's why I was confused.
Yeah, I see it. But he'd have to prove that. There's no proof of that. When you
Yeah, no
read the
proof.
matter, you see that when you go to the Court of Appeals, this is based on the motion that there was something done in the lower court. And the facts that the decision that was made by the lower court, that the
Mhm.
judge erred in his judgment. There's nothing in the Supreme Court that speaks of theft. Nothing.
I
So
keep
how you
seeing
bringing
that
up
actually,
theft
where they keep
now?
saying he was wrong.
He was wrong.
Yeah, you're wrong.
No,
And
not the appellant, that the appellant was saying the judge, those were wrong for their decision.
Right. But I'm saying is the judge was not wrong. He has to
Yeah,
be
because
fair.
I thought that arrangement was pretty fair.
Mm.
Yeah, it was fair.
Mhm.
You see, but see, he did it to himself. Look at it. Look at it now. There's no emotions in law, right? But look at when she put in her affidavit. How she started off? She tell you the man take the jewelry back that he gave
Yeah.
her. He
That's
take the
another
ring
thing.
back.
How
That's
was
a
there no
petty
cross
man.
examination of the affidavits before they got this far?
What you mean?
There was another part where it was saying that the both of them submitted affidavits and there was no cross examination of both, so there
Yeah,
was
I
conflict.
saw that.
Yeah, I saw that. I read that too.
Mhm.
How is that even possible?
I don't know. They should have done it. But you know, he's a pastor, you know.
Mm.
So they probably didn't want to dig too deep because that's too much information.
But so wait, okay, just to be fully clear, they can do this in the courts without representation?
Now, when you say, don't forget now, you can do things in closed chambers.
Mhm.
It can be
Okay,
done in
see?
closed chambers.
See, and reading this, I don't remember seeing anything about there being some sort of representation on either part, so.
What do you mean,
I mean,
lawyer?
aside from
lawyer
where it's saying Ramona those, like,
That's their
because
counsel.
it's supposed to, the responsibility should fall on them to say, okay, all of this is happening. They're supposed to be the ones cross-checking things before it goes in.
Yeah. That's the lawyer's job.
So them not being mentioned inside, or I may have missed those parts where they were mentioned.
No, they didn't mention them. No, they did not mention them saying anything.
Yeah, so that's what made me feel like they weren't doing anything really, or like they weren't there.
No, they probably would have been there, but the judge may have just direct read it and then move on. Because if this had come before me and I'm reading this, I'm already turned against this man. He cannot be serious
No,
at
no.
this age. At this age, it doesn't make any sense. Why are you doing this?
Yeah. It's wrong.
You don't want to give this woman anything. Now, it's one of them committed whatever it is for the grounds for the divorce. But this woman helped you in this business all of these years. And,
Mhm.
and how you turn around saying that she stole some money now and she was your wife?
All these years.
All these years, 20
Mhm.
years. And you saying that 5 years somewhere down the line, she stole some money from you? No, this man can't say it can't be right.
No. Must be about Alzheimer's.
Yeah. You don't have that. Because I
Hmm.
bet you if you and I get dressed tomorrow and go to the church, we see him right there with a new woman.
Yeah.
No. No.
Yeah.
No. So yes, he did form the company, but then like the judge said, he didn't bring in any evidence that he owned 5%. And someone who has a 5% interest is actually not managing all the assets of the company. So what happened to the other shareholders?
Children, eh?
The children, so where were they? What were they doing?
Mm-hmm.
So she bring her in there. She doing all the work. And at the end of the day, you want to give her nothing.
Yeah. Yeah.
No, it won't work.
So what do they mean by learned trial judge? I saw this was throughout the case. What does that mean?
Learn a
Why did-
trial judge.
Yeah.
That's
Why
just
did
the
they keep?
that's the judge who heard the matter.
Okay.
That's all it is at the trial.
Okay.
I start my video.
Hmm? What you ask?
No,
I'm,
Talking to the technician, sorry.
Oh, I forget. You more interested in, hey, she's more interested in her air condition. Okay.
She gonna when BPL come to the door.
So don't forget, I told you last class when they use the word learned.
Yeah.
Learned just means that they've studied law.
Yeah, they've read it. Okay.
Yeah, they've read it,
Yeah.
and they have
Yeah.
quite a bit of knowledge,
Okay.
experience in dealing with this matter. So that's my learned colleague.
Yeah.
An expression that they use. All right. So you all had some homework. Please tell me that you did have a chance to look at that last question, the rule in equity, the Regal Hastings versus Gulliver. Okay, silence now.
Little.
See me saying, uh-oh.
Who?
Yes.
But actually, it's just been one of those weeks. I'm not gonna lie. We've been very, very busy. Oh, God.
It's been one of those.
It's one of those times I didn't read. I'm sorry.
What is wrong with you all?
We forgot about this one.
To be
Yeah,
fair,
but
we
you're
did
too
read the
busy.
Supreme Court for the Chisholm stuff,
I
and we
figured
read
that.
the last chapter.
Right. I figured that.
So
You're
we
too
should
busy
get that
trying to
much.
read Chisholm. Mm.
It was interesting though.
He was being nosy. That's what happened.
See?
Yes. This isn't much but company law in there.
Mm. No, no,
No, not at all.
not at all. Yeah.
Just that it was a company was 5%. That's it.
Nothing more.
No. So Nathaniel ain't missed nothing. Nothing at all. All right. So this question is on the final exam.
The equity question?
Yes.
Okay.
Equity.
Yeah.
Number 3.
Number 3. And the shortened version of the Regal case, you can find it online. You see how nice I am?
Yes.
Can't complain when you sit in that exam and say, well, what is this? I know how you all go.
Mm.
So the Regal Hastings, like I told you all, that is what is the leading case, and it stipulates the rule against directors and officers from taking personal advantage of corporate opportunity, which is against their duty and loyalty to the company. So in this case, Lord Russell of Kilowatt made his comments. And all I want you to do is comment on it. So you notice he's talking about the director's duty of loyalty to the company. So you need to read the facts. He summarizes his facts in the link I sent you. So you need to read it.
Did you send us a new link?
No, I sent this last week. I sent it last week, and it's in big print, so you can read it. I hear you looking. Or you could go, because Wikipedia gives you you can read Wikipedia, give you the facts and the judgment. But the link I sent you is the link for this judge himself.
This is a long read, right?
That's the
Like,
40-something pages.
Yeah, but you only want to read his portion.
Lord
Russell.
Lord Russell, yeah, okay.
Only Lord Russell you want to read.
So
To
that's
see
the
why he
first part
said
then.
what he said.
That's the first part then.
No, he's not in the first. He's not the first
Hang on.
judge to comment. Look down, you'll see it tells you each judge. The first judge, I think, is Lord Wright.
Okay.
But you want Lord Russell.
Okay.
And he gives you his own breakdown, little summary of the case. And then he goes into making his decision. But the overall decision, the concluding decision of this case is by Lord Wright.
So don't read Lord Wright, just Lord Russell we're concerned about.
Yes, but I'm saying you could read Lord Wright. If you go to Wikipedia, you can see what Lord Wright said.
Okay.
Under judgment, you'll see what he said. But this quote is from Lord Russell. So if you go on Wikipedia now in judgment, it says the House of Lords, reversing the High Court and the Court of Appeal, held that the defendants had made their profits because they sold the shares for more, almost double. Held that defendants had made their profits by reason of the fact that they were directors of Regal and in the course of the execution of that office. They therefore had to account for their profits to the company. And he said that the governing principle was succinctly stated by Lord Kilowatt. And he says the rule of equity, which insists on those who by use of a fiduciary position make a profit, being liable to account for that profit, in no way depends on fraud or absence of bona fides, or upon questions of consideration as whether the property would or should otherwise have gone to the plaintiff, or whether he took a risk or acted as he did for the benefit of the plaintiff, or whether the plaintiff has in fact been damaged or benefited by his action. The liability arises from the mere fact of a profit having, in the stated circumstances, being made. So what he was saying, but it doesn't matter how it was done. As long as a profit was made, then he has breached his fiduciary duty. So this isn't a long answer. That'll take you 16 hours to write.
Okay.
So that's a giveaway question. Do you agree?
So when we answer this, we can put word for word, eh?
What you mean, word for word, where?
When we
No.
commenting.
When you comment, and you should have already summarized that. What did he mean? You know what the duty is.
Mm,
Yeah. So you probably would just summarize it. Your comment could be, in this case, Lord Russell took this view because.
okay.
Yeah. The main point is that I want you to read the case so it could stick in your head that
Mhm.
duty of loyalty is from the case of Regal Hastings. And it doesn't matter whether it was done by fraud. It doesn't matter. The point is that if you make a profit, you're going to have to account.
Yeah.
There's no doubt about it. You have to account. All right, so now let's move to liquidations. I heard some eager beavers told me that they read it.
I did, and I scratched I have this thing all scratched right up.
Why?
Because I had a lot of questions.
Oh, okay. Who else have it scratched up? What's all? I don't know what all the scratching is. Should I let her go through it and tell me what the scratchings are?
Well, first of
Yeah.
all, I realized there was a lot of IBC references, and I thought I printed out the IBC Act, but I was more so focused on the domestic one, so that one was the only one printed. Where was
Okay,
it?
go ahead.
Hang on, I'm trying to find it. My first real question was where there, hang on, this is involuntary liquidation for under where it says under section 211. Oh, that's another thing. I didn't realize there was a separate act until I got in this, so I didn't know that until.
Winding up.
Yeah, I didn't realize that until afterwards, so I didn't print that, and it was kind of
okay.
hard to find, so go through it. But there are two things in here. One where it says whenever an event occurs, the occurrence of which the articles or memorandum of association provide the company is to be provided for the company is to be wound up. What occurrence or event is this thing talking about?
Which page you on?
Second, third page.
1, 2, 3. Voluntary or
Yes.
involuntary?
Voluntary.
Okay. So where are you?
Number 2.
2. Whenever an event occurs.
Yes. What is the event that this would be referencing to?
Whatever event that they stipulated. You
Like
can
if
form
there's-
a company. You can form a company, and then you could say that the company will be wound up after completion of the purchase of a building. Whatever event,
Oh.
yes, like that.
Okay. Sorry, I was a little confused by that. Okay.
Yeah.
So after the sole purpose is completed.
Right,
then
right.
wind it up. Okay.
What's your next one?
Further down where it says as under section 12 to number 2, I wanted clarity on that where it says on expiry of the period or occurrence of events. You just clarified that if it's for the sole purpose or whatever purpose is laid out, then that would be the
Yeah.
event. So I had actually been asking if that meant like a merger or something.
It depends. It depends on whatever the event is. Don't forget now, you could form a company as a going concern, or you can form a company just for a particular purpose. So
Okay,
you could say you form a company just for 6 months for whatever transaction, or you could actually state the transaction for which the company is being formed for.
Could this also, number 2, also refer to a limited duration company, because the thing on the expiry of the period?
Yes,
See,
it could be that too. Yes.
Okay.
that's the
Okay.
same thing?
Yeah, it's for a particular time frame.
Okay, because I noticed for the previous one, the number 1 above that does say the period, if any, fixed for the duration of the company. That's
Yeah,
talking
uh-huh.
about limited duration companies, right?
yeah. Mm-hmm.
Okay, see? Getting there.
Okay, I'm glad you're getting there.
There was also, okay, for number 4 on the following page.
Okay, hold on, let me go to the next page. Oh, at the top?
Yes.
Okay.
Okay, I have, hang on a second. I was a little confused on this because for where it says the date of articles of dissolution is the date of commencement of the winding up. I understand that because that's the date that that the directors or whoever would print, and that would be submitted to the registrar. This
Mhm.
part here where it says of the winding of the IBC unless the articles of dissolutions provide for another date which shall be within 30 days of registration. I'm a little confused on that.
Okay, why are you confused? If the
So-
date, if a date is actually stated in the articles of dissolution,
Yes.
then they're saying that that is the date that you will use.
But I'm where it says provide for another date which shall be
Right.
within 30 days. So is this, are they saying we can submit the articles and then provide a date as to when it can
No,
commence?
no. In the articles of dissolution, it would state a different date. But that date has to be within 30 days of registration.
Okay, see now, that's where my confusion comes in. So where is this registration?
With the registrar general.
But the registration would be the articles of dissolution that's being submitted, wouldn't it?
For
Or is there something
registration,
else?
yes.
See, okay, from my perspective on it, it seems like it's 2 different dates and 2 different things being sent
Okay,
in. So I'm trying
so
to
they're saying
clarify.
there's two. Okay, so it's saying there's 2 ways you can do it.
Okay,
You can execute your articles of dissolution and submit it to the registrar for registration.
mhm,
And they're saying that the date of that article is the date for the commencement of the winding up. So
okay,
you can
I
have
get
it in
that.
there. You can have that. Or you can do it another way, whereby within the articles of dissolution, you state the date that you're going to commence.
Oh, okay, okay,
But
See.
whatever you do, it has to be, that date
Within
has
30
to
days.
be within 30 days of registration.
okay. Okay, that's what I didn't get.
Right. So you may do it today and then get it registered. But what they're saying is you can take your articles of dissolution and you can say that your commencement date is the 15th of September. But you will have to make sure that you get it registered within 30 days of that date. You can stipulate the date within the date of the resolution of the dissolution, but you have 30 days in order to get it registered.
Okay. All right, so I got that now.
Okay.
Same page, further down,
Mhm.
section 92. Again, I didn't have the app to go back over it myself, and it was kind of hard to find, so I wasn't sure about this.
Okay.
92, the wording in that, I was unsure of what it was trying to say, really.
You mean 90 subsection 2?
Yes. Sorry, I hadn't read it wrong.
Yeah,
Section,
you
yeah.
said 92 and I looking for 92.
Mhm.
Sorry. section 90, subsection 2, yes.
Okay, so they're saying now, you're in liquidation.
Mhm.
And it says that if there's any surplus that is left after you pay all of the debts, they're saying before that surplus can be applied for any purpose. This is what's left over after you paid all the debts. And it says that before you can pay that to anybody, you need to see if you owe anybody interest on those debts
Is this
during the
part
period
where
they
you
were
want to-
outstanding.
Sorry?
Okay, so let's say you have debts. The
Mhm.
company has debts. And let's say your debt says, I owe A $100, B $200, C $300. So 3 and 2 is 5, 1. So in total, I owe $600, right?
Mhm.
I have collected, let's say I've collected $1,000. So I now have a surplus of what? $600. Section 90 subsection 2 says, before you could disburse that $600, you have to go and see whether or not those creditors A, B, and C are owed any interest during the period when the company was doing is winding up, and you have to pay it.
Okay, I have an idea of what you're saying now.
Okay, tell me what I said.
This is like what we were talking about with the shares, with the chapter on shares where, oh goodness. Hang on a second. Oh gosh, what's the word?
With preferential.
Yes,
Mm-hmm.
the interest on shares for preference shares and ordinary shares, right?
Yeah, but this is before that. This is talking about if you have any debts.
So this is just debts.
Debts.
Okay.
Because you don't pay interest on shares.
No, I was saying it was similar to that.
Similar to
sorry.
it, yeah. So any debts that you owe, they're saying that if during the liquidation process, they were accruing interest should have been paid, you cannot just pay the nominal amount. You must pay the nominal amount plus any interest that accrues.
Okay.
And then notice what subsection 5 says. No interest shall be payable if the liquidation is concluded in less than 6 months, or the amount is less than $500.
Yeah, I saw that.
Okay.
Okay. This is subsection 3. I wanted to know, just to be sure, can they also be pari passu?
Subsection. What section 3 where?
It says equally, and I just wanted to make sure they would be, at the same. Oh goodness.
Where are you?
She's going
Same
down.
page, just yeah, same
Oh,
page.
90,
just number-
90 subsection 3?
Yes.
Okay, so they're saying that if there is interest accrued, they rank equally.
You mean each person would be ranked equally, or
Each debt.
the debt towards the debt and everything else would be the same? Okay,
So right. So each debt, the interest is attached to the debt. They're not separate.
okay. I was thinking something else. Interest is equal to debt. Okay.
Miss Archer.
Yes.
Okay, in section 90, subsection 5, it says no interest shall be payable if the liquidation is concluded in less than 6 months, or the accrued amount is less than $500. Why did they word this like this?
What you mean, why?
Less than 6 months? You still owe somebody?
Yeah, but they're saying that interest will not be accrued. So what it's doing is looking at how, if you're able to liquidate within 6 months, which is very quickly,
Yeah.
then you don't pay any interest.
Mm,
Don't forget now, you normally pay interest because of the time period.
yeah.
So say if
Okay.
it takes you 2-3 years in order to liquidate, of course you're gonna owe me interest.
Yeah, yeah.
Yeah.
Okay.
So they're saying you can do it very quickly. There's no need to pay interest.
Okay.
There's no need at all.
All righty.
Any more questions?
For number 6, same page, where it
Okay,
says
number 6.
liquidator advertises for creditors during the liquidation process.
Uh-huh.
It's the
And then right
newspaper.
below, see, that's what I thought, but then right below on number 7 says notice of dissolution must be published within 30 days of registration.
Uh-huh. So what was your question?
Are they the same thing, or is this actually 2 different notices that needs to be done, or 2 different advertisements that need to be done?
No, it's one.
No, it's one.
Because
One.
it's saying
Because
2.
you have to appoint your liquidator, so they're the ones who have to carry out this liquidation process.
Mhm.
See, but that's what I'm
Okay,
saying. The
no.
liquidator advertises to creditors.
Mhm.
And then it goes back and says notice of dissolution must be published. So I was trying to figure out what was the difference for them to be needed to be listed separately.
They're only telling you what they have to do.
What to do? Yeah, step by step,
Yeah.
making it clear. So you know that your next step is you have to advertise. So
And
how
that's
do
the
you
one
do
that goes
that?
in the paper.
Right. And so how do you do that? The next step says
That's
you have to
right.
put a notice of dissolution
Okay, I get that.
and publish it within 30 days.
I get that.
See,
That's
everything
number
has to
7.
do with the timing, right? Everything has to do with the timing. So this is I always get this question. This is a notice I clipped out of the paper. It says notice. Galaxy 86 Limited, in bracket, involuntary liquidation. Notice is hereby given pursuant to section 138 subsection 4 that the above company is in dissolution commencing on the 4th day of March 2021. Articles of dissolution have been duly registered by the registrar. The liquidator is Forbes Manor Company Limited, P.O. Box N1576, Nassau, Bahamas. All persons having claims against the above named company are required on or before the 25th day of March 2021 to send their names and address and particulars of their debts or claims to the liquidator of the company, or in default thereof, they may be excluded from the benefit of any distribution made before such debts are approved. Signed by the liquidator.
Liquidator.
These are always in the paper.
Mhm.
Yeah. Like I said, number 6 just confused me because it seemed like it was number 7, but the way that
Everybody,
it's listed
yeah.
seemed separate.
No,
It seemed like it was a separate thing.
Yes, tenuous
No.
duties. Yeah.
Yeah. Mm-hmm.
See now, when your company goes liquidation, you appoint your liquidator, so they are the ones who taking over the disposition of the assets now. So they have to do all. They tell you what he has to do.
What he has to do. And remember now, the directors are still there, you know.
Yeah.
Okay, so we established that 6 and 7 is basically the same thing. Going down
No,
to
two different acts, two different acts, two different acts.
what you mean?
One is telling the liquidator what he has to do. The other one is an actual advertisement in the paper for the creditors.
Yeah, I get that, but that's what I'm saying. Like you're saying that at the end of the day, what he is doing will still end up. Okay, now now I confuse again.
Why?
Oh. The advertisement that he's making for the creditors will basically be the notice that's being published, is what you're
Yes.
saying, right?
Mhm.
Okay, yeah. So that's what I mean. That's what I understood from that. I
Yes.
just wanted to make sure there wasn't something separate that was
No.
supposed to be published somewhere else or whatever.
No, no.
Okay. Then going to 11, where it says, liquidator publishes a notice that a company has been dissolved and has been struck off the register in official gazette upon issuance of certificate of dissolution.
Mhm.
Is that still something that's being done? Is that like
Second
something?
notice. That's the second notice, JL, remember?
Yeah. In the Guardian
you-
or the Tribune.
Oh, okay. Okay, I forgot
Yeah.
about that one.
Yeah.
I forgot about that one. Okay,
Mhm.
but seeing it's saying official gazette. So
That's
I was
the
thinking
Guardian or
the
Tribune.
The Guardian Tribune, yeah.
no, I was thinking the gazettes like what
Oh, I know what you
Publication?
mean. Yeah,
yeah,
no, not
that's
that.
what
no.
I was thinking. So
No.
I was confused by that. Okay.
No, that is the language. No, that's what you call the newspapers, the official gazette.
So for my ease of reference, I'll just put paper notice or notice in the newspaper.
Yeah, or put Guardian Tribune.
Okay, because that one had me a little lost.
Oh, okay.
See, but you do see that I went through it.
Yes, yes, yes. And it's helpful for the others who didn't.
We can't say that. They may have gone through it and just didn't have as much questions as me because I wasn't as
But that's
exposed
true
to
too.
this.
Well, that's true too.
Okay. Not that. Okay. Moving on to involuntary liquidation.
Uh-huh.
That's the next page. It says the winding up and dissolution of a company incorporated under the IBC Act may be wound up under the same circumstances as applicable to a company incorporated under the Companies Act. Notice that I can't remember exactly where because we just going through the notes right now, but I noticed something similar to that was mentioned earlier. And I did not understand what that meant. Or at least why that was, I should say, because I have why here for my question.
Okay, and your why means what?
My why as to why the IBC can be done under the same circumstances as a company is one.
Okay. And that is because the company is winding up act?
Mhm.
Let me see where it says it in here. Let me find it for you.
It was
I think I
before
made
this. Not this page. Not that page.
Oh, I'll have to find the,
I think this is it. Hang on.
hold on, I'm trying to find my copy too.
Oh, I don't have the act in front of me.
Yeah, you need to have it because it tells you winding up. Okay, you know, this appeal. It says it's somewhere in here. I have to find out. I don't know where it is now. Not that one, no. Says it's somewhere that it applies to both. Find it.
Kendra or Blair, do either of you know which?
Trying to look.
I'm trying to find it right now. And I didn't make a note.
Like I said, I didn't have much exposure and I didn't know about this other act until afterwards.
Oh, okay.
Right.
We're trying to find it now. Oh, I hear music playing.
That's my son playing.
Oh, Lord. Leave him alone. Leave him
I-
alone. Leave him.
Yeah, they do DJing.
Oh, okay, okay. I'm trying to find.
Is it affecting you, Miss Archer? I can put on mute.
No, 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 no. I say no.
Oh, okay. Okay.
Uh-uh. Leave him alone. Okay, let me see. Find it. Because it applies to both. I think I have to pull down my IBC binder. I have my company's act binder. Let me pull down the IBC one.
See why it would be so helpful to get one of those updated and consolidated stuff.
Yeah, right. Get it from where?
No, I'm saying that it would be helpful if they did one, so we could have one.
Yeah, because you have pieces of paper all over the place. I have little tab here and little tab there, and how to find that. It's a different story. And I would have gotten rid of that a long time ago. That's not it. Okay, where is this? Constitutions. Winding up. Ordinary powers. Yeah, man, there's something that came out because all of the winding up section was repealed. There is something, but to find that now is hard. That was 2011. Not amendment. 2011. Okay, so the amendment in 2011,
Mhm.
it says sections 89 to 130, 137, and 142 to 163 of the IBC Act are repealed and replaced by the following. Section 89, winding up and dissolution. A company incorporated under this act may be wound up under any of the circumstances insofar as they are applicable to a company incorporated under this act, in which a company incorporated under the Companies Act may be wound up. And subject to the provisions of this part, the provisions of the Companies Act relating to winding up and dissolution should apply mutatis mutandis to the winding up and dissolution of the company. So it's the IBC Winding Up Amendment Act 2011.
Okay,
Okay, got it?
okay, so I'll try to see if I can find that and print that off.
Mhm. Earlier I know it was there, but I have it in under the IBC Act. And I didn't pull that one last night. Okay, let me get back my
Wait, so does
papers.
that answer the why that I had?
Yeah, you asked what that means. You ask
Yeah,
why is it
okay.
referring back to that? Yes. That's what the act is saying.
Okay,
That if you're doing an IBC, you go to the Companies Act, winding up, and you follow it.
okay, these next two, I think were these the last? Yeah, my next two questions are the last questions, and they're rather simple. Where it says C, the company is insolvent.
Where
I
you?
understand what insolvency is.
Which page you on?
Same page, right below.
Oh, go back there.
Yeah, same page.
Okay.
Where it says C, the company is insolvent.
Okay.
I understand what insolvency is, but what would make it insolvent?
That they,
When you cannot pay your bills.
No, that's what I'm saying. I understand what insolvency means, but like, what would cause a company to become insolvent?
Bad management. No business. A lot of different things. It's when a company is failing.
able to
Uh, I'm- Yeah, I'm trying to figure out if try to give an example of a local company
Oh,
that became insolvent. Oh, I know one. One on Gladstone Road.
Bills?
Yes.
oh,
So that's where that's where you can't pay your bills.
Okay.
Yeah. So the company was in trouble because it was rumored, quote, that he was spending the money on gambling.
I just went
He
down.
couldn't pay his bills, he couldn't pay his staff, he couldn't pay for his inventory.
So who he had in place to pay the staff? Like he didn't have a financial controller or
I
somebody.
don't know. He probably used to go in the till and take the money. I don't know. but that is what it was.
Wow. And they were doing so well.
Doing so well in terms of pricing, yes, and making a lot of money.
Yeah.
But if you do not
Yeah.
manage the money, remember, I told you all I think it was the first or the second class that a lot of people believe in a form a company, the money that comes into the company belongs to them.
Mm-mm.
And that is not true.
Not true, yeah.
They're just a shareholder. So unless they get a position within the company where they're going to be paid a salary, they cannot put their hands in the till. It belongs to the company. But then, like I say, it was rumored that was one of the problems, gambling.
Mhm.
Okay.
So the court had to wind their company up then.
I don't know what happened. Not the court.
Oh.
I don't know if the court did it. I don't know if the creditors went to the court
Oh,
or he just hired a liquidator. I don't know.
Okay.
Okay, next question.
Yeah, that'll be the last one, where it says the members are reduced in numbers to less than 2. I know we did company, I know we did incorporation and stuff earlier.
Uh-huh.
I just couldn't remember, and I probably should have just gone over it myself, but I couldn't remember. Was it a requirement to have more than one?
Mm-hmm.
Mm-hmm.
I know it was a requirement for more than one director.
Now, don't forget now, when you're talking about a company being wound up, where it says members are reduced in a number to less than 2, you more or less talking about a large company. So what the legislation does is it take into consideration in the event there is, what's the lowest number you will go to?
1. I mean, I know you're saying 2, but like I said, I only remembered where it was saying it was a requirement to have 2 or more directors.
Mm-hmm.
And I only remember that towards the domestic companies. I don't remember that in regards to, where is that? I don't remember that in regards to IBCs or shareholders.
Yeah, but it's saying it, I think it's just put there in the event that there are maybe more than, and that when you get down to that number, you can actually go into liquidation. Because if there's one person, there is no dispute.
Mhm.
Okay, when you put it like that, that makes sense.
Yeah. So it's like a cap share. In the event, let's say you had 8 or you had 10, they're saying when you come down to 2, you can put it into liquidation.
Okay, so I did find a note for domestic where it says 2 shareholders, 2 directors,
Mm-hmm.
but I only see that in the domestic part.
Yeah. Yeah, but if there's only one, they could bring it to an end.
Okay,
Mhm.
so those are my only questions.
Okay, anybody else with questions?
Much.
No?
No, not at the moment.
We
Okay,
can still go back over it if necessary, if possible, but those are my only questions in that.
okay. Where's my beginning? Well, this chapter only really gives you the steps. So it's just the steps.
Mhm.
I think we should go to the final exam and then we'll see how to apply this. Okay, so do you have your copy of your company's winding up handy?
No, I don't have that. I have that printed to work.
Okay, you have it online? You can get it online?
I could go on laws online.
Yeah. Go to laws online. Take out your paper that says notes for final exam. So you know that the Regal Hastings is on the exam. That's one. And you also know that the question we did, the principles of corporate governance, is on the exam.
That's number 3.
No, that's number 2. Regal is 1. And the second one is corporate governance. Remember when we did that question on
Yes.
corporate governance? And
Mhm.
I've added risk to it. Do not spend all day and all night writing about corporate governance and risk. I know just how you all go. Writing me 6 pages. And then you begin to realize, oh my God, there's 3 more.
God. That's no killers, man.
I am not. 2 questions you already know. Because we did those in class. Now, let me see. Because your capstone is just so easy. What? I have focused the remaining 3 questions. Roll the drum, roll the drum. On liquidation.
Hold on, say
How
that
that
again.
sound? Huh?
Say that again. So we
Three
still have to do
questions.
capstone?
I said, gosh, the capstone was just so easy. I decided I will do the remaining 3 questions on liquidation. Okay,
Anything in particular?
I'm about to tell you now.
Oh, okay.
So one question focuses on, is easy.
What's that?
Let's say one question is rather easy, it's short.
Oh, okay.
And that's talking about the different types of liquidation and why each one is different. So that's easy. It'll also ask you about fraudulent trading.
We learned it.
versus wrongful trading. But they're 2 different things. What's the difference between fraudulent trading and wrongful trading?
Fraud is, I guess, illegal. Well, I mean,
Yeah, more or less.
more or less, yeah.
What's wrongful trading?
Who could be, following some kind of rules or something and abuse, or maybe I don't know if I want to use that word.
Okay, so wrongful trading is when you carry on trading, but you're insolvent. That's wrongful trading. So it's like the company can't pay its debts, but you're hoping that if you do this one more trade,
Mhm.
you may be able to get out of it. So there is a distinction between fraudulent trading and wrongful trading. So in the Winding Up Act, fraudulent trading is section 243. And when you talk about wrongful trading, you can have a look at section 230 that speaks to misconduct in the course of winding up.
Ms. Archer, can you repeat that? My computer had a glitch.
Oh, section 243 is fraudulent trading in the winding up.
Mhm.
And wrongful trading, I said, have a look at section 230, misconduct in the course of winding up.
Okay.
So this question again is another short question. It has 3 parts, but they're very short. So you're distinguishing between the fraudulent versus wrongful trading, but you also must tie in what are the consequences if you're found guilty of either one. The third part of this question speaks to the order that a liquidator must follow to distribute its assets.
This will be the steps that they have to do in order to dispose of the assets.
Mm-hmm.
Okay.
So, yeah, when they're distributing it.
Like
What's
who
the
to pay
order that
first?
they do? The order,
Like
the
who to-
order that they do it in.
Like who they have to pay first?
Yes.
Okay.
And that's also in the Winding Up Act.
Mhm.
I remember the section on my head last night. I think it's 236. I think it's 236. Let's see.
I don't think I'm finding the right thing because it stops at 101.
Where are you?
101.
This is the Companies Winding Up Amendments Act 2011. What you looking at?
Okay, no, because I pulled up the winding up rules first. I thought.
Oh, you pull up the rules. No. Pull up the act.
Okay, so
Let me
the
give you-
act was, wait. Okay, so I'm on the laws online and I'm trying to figure out which one of these I'm supposed to use.
Okay, hold on. Let me go there. You on the laws of the Bahamas?
Yes, I ran under where it says Companies Act.
Okay, hold on. Let me get there.
Section 236 says distribution of the company's property.
Yeah, no, not that one.
Yeah.
Did I remember it last night? I should have write it down. Hold on, hold on.
Let's see.
I probably did. No, I probably did. Let me see. Did I? No, I did not. It's here because I just read it.
Yeah, it's,
Hold on, let me find this act for her
okay.
so she could find it. Companies. PICOMP. Okay, all right. So look at the very left column where the numbers are
Yes,
under the Companies Act. Go down to the number that says 2011, 2011, 0053.
okay, that's the one. I think I opened
I think
that.
that looked like amended by, you open that?
Yeah, that has 42 pages.
Mm-hmm.
That sound like it.
Yeah, that's right.
Okay, so there's the original thing from this amendment, which would be which one?
What do you mean the original thing?
Because you're saying this is an amendment. Is there something else?
So this is amendment to the, this is the amendment to the act
To just the Companies Act,
and the
winding up-
IBC Act,
Yeah.
remember?
for just the, okay, so this is just the amendment towards the rules for winding up then. There is no separate act at all for winding up.
No, this is it.
Okay, that's what I'm trying to clarify.
Yeah, this is it.
Okay. That's probably why I couldn't find it. So this part that says where I said I opened this that said rules. What is this really?
This is the rules to the Winding Up Act for the liquidator. Giving him all of
This
the
is for the
forms.
liquidator.
Yes,
Only
these
for
are,
the, okay. I don't need this then.
yeah, these are the different forms that need to be completed as they go through the process. Like the format for the petition.
Mhm.
If he resigns, what forms he need to prepare. Like when he's preparing the statement of affairs, how that needs to be prepared. If they're having a meeting of creditors, how that meeting should be set out. That's what the rules are about. It's procedural. Procedures are never in the act itself. The procedures are put in rules.
Okay, and we're not focusing on that.
No. We're actually just looking at how to distribute these right now, these assets. Oh, let me find it. Section. No, not here. Why is this thing eluding me?
I don't know.
And I just saw, I just see the thing last night. I should have written it down. Provable debts. Preferential debts. Yeah, that's it.
36 distribution.
Yeah, 236.
Okay.
And then a little bit of 237.
Preferential debts.
Mhm. That'll come in again when you go to another question. But these are very short because there are three. This question has three very short questions. The types of liquidation and how each one is different. The order to distribute, so that's not long.
You said order to
And-
distribute.
Yeah,
Oh,
the
sorry,
order.
order that a liquidation was for, okay.
Yeah. And fraudulent versus wrongful. So
Okay.
that's one question. So far you have three questions. Corporate governance and risk in one. You have legal as one. And then you have just a general question on liquidation in three parts. The next question is where you narrow it down to another three-part question, so it's not long. And you're just looking at three particular claims coming into the liquidator. So one is that a creditor is saying that during the windup, one of the directors continued trading. So what is that?
Fraudulent or wrongful?
That's wrongful. See,
Okay.
tricky.
Mm-hmm.
Know the difference.
So this next question is, you said three claims coming into the liquidator.
Say it again.
You said this is a question, three claims coming into the liquidator.
Yeah. And that's the first one. Directors continue trading. So you're going to discuss what the liquidator is going to do.
Okay, can I get the full thing again, please? I think I mixed this up.
Okay, for this question.
Yeah.
Okay, so this is the third question. This one has three parts also. So I mean, it's a very short answer.
Mhm.
So the first matter to be discussed is that one of the creditors is saying that during the windup, one of the directors, he continued trading. What's the effect of that? You know the section for wrongful trading, right?
What's that, Ms. Archer? Section 4.
Strike section 244. Remember, I pointed you first at section 230 for the
What?
other question. I did that 244. It's called insolvent trading. Because remember now, wrongful trading means that you're still trading and the company is insolvent. The next thing that the liquidator is saying is that some of the directors want to form a new company in the same business, but the liquidation isn't complete. Can he restrict them? Can the liquidator restrict them from starting their own company in the same business?
Wouldn't that be like a case with Penrose fee with official receiver?
But can they do it?
I mean, unless there's some sort of thing under, what was it, the Insolvency Act or the or the, oh goodness, what was it? The Insolvency Act 216 or 213,
Okay.
one of them, I can't remember that, oh gosh, but anyhow, unless they were disqualified under the act somewhere, they were allowed to move to become director somewhere else. However, they needed to take a test given by the court. I'm trying to remember the details of it. Anyhow, in that case, they couldn't disqualify them. One judge tried to disqualify them, but they were saying it was wrong to do that because although the other company hadn't been dissolved, there was no evidence of them mismanaging or whatever it is, so they couldn't disqualify them from becoming directors of the new company.
Okay. So you can use that.
Ow.
Yeah. And it really boils down to whether or not they are fit and proper. And the third issue. Go ahead.
You said the liquidator is saying that who wants to start a new company? The director?
Directors, yes.
Okay.
So they want to form a new business can you repeat
The
the
same
question again?
business. They want to form the same business. As soon as the liquidation is finished, they want to form the same business. That happens. And the third scenario from the liquidators is he has a claim from the employees for backdated wages. Unsecured creditors for some unpaid goods. And he has a debenture secured by a floating charge. He wants to know in what order to pay them.
So when you repeat it first and then I'll ask my question.
Okay. The liquidator wants to know the priority to pay these people. One is he has employees with some backdated wages. He has some unsecured creditors for some goods that are not paid for by the company. And then he also has a debenture that's secured by a floating charge. He wants to know in what order should he pay them.
So all we're doing here is just saying this one should get paid first, that one get paid second. that
Yeah,
one
just
get paid
put 1,
third.
2, 3.
Okay,
Okay.
Yeah, these are short answers.
okay.
So you shouldn't be there all day mulling. Because I'm
Fiddling.
already telling you what's on it. I'm telling you where to go to look for it. You have an idea. So when you see the question, you should know exactly what to do. So you're looking at section 235, 236, 237. Provable debts, distribution of the company's property again, and preferential debts. What if you need secured creditors? 238. Yes, 238.
This is the question you just gave us?
Yeah.
Oh, okay,
The one with the priority,
yes.
235, 236, 237, 238. Once you've read those sections and you look at what I gave you, you should know exactly what order to put it in.
Mhm. Okay.
So that's the fourth question.
Mhm.
Yes.
Yes.
Fifth question.
I thought that was the
Okay.
last.
No, don't try it. The fifth question is a company is in compulsory liquidation. And the liquidator needs to know what to do. And he has how many? 4, 5. 1, 2, 3, 4, 5. So again, they're short. The only thing that's really long is Regal, which you know, and the corporate governance and enterprise risk management. Okay, so let's look at compulsory liquidation. The liquidator has some problems. He wants you to help him. He says that 3 months before the winding up started, the company created a floating charge over its assets to secure an overdraft. The charge was registered.
This is a
The
question
bank
you're supposed to
allowed.
write? We supposed to write this question?
Yeah, this is the last question on exam.
Oh, I thought you already, I thought this was some other example just giving us.
No, this is the last one.
Okay, but I
said
got,
this
okay.
company is in compulsory liquidation,
yeah.
and liquidator wants some advice from you. He said 3 months before the liquidation winding up, the company created a floating charge. And they wanted it to secure an overdraft. The charge was registered. Now the bank allowed the overdraft to go up to pay wages for the employees. And you need to say whether or not that should have been done. The second one he wants your advice on is that an individual has put in a claim and he's alleging that a slanderous statement was made by the MD. The liquidator said, what should he do?
What should a liquidator do?
Repeat that one, please.
An individual is claiming that the MD made some slanderous statement. And he's put in a claim also.
It's actually already have these written out, eh?
What, the exam?
I mean, the
Oh,
question.
what you reading to us?
Yeah, the exam is finished.
I mean, what you're
Finished.
reading to us, if you could have just forward them to us.
Yeah, right.
Because we might have missed some words.
You ain't miss no words. When you see it, you're gonna know just what it is. Make sure your brain is percolating. The next thing the liquidator wants to know is 18 months before the winding up, when the company was doing well, it got a floating charge. In favor of a company that is owned by one of the directors. What should he do? And the last thing that he has to do is, he has some bill, not last, before the last, this is the fourth one. He said he have some debts here. He wants to know what to do with them. He owes VAT, he owes corporate tax, and he also has some salary here to pay. What should he do?
This question, what you mean, what he should do? You mean the order to pay them in again?
The liquidator, yeah,
So you just put in 1, 2, 3, 4 again?
yeah. You have to say whether or not he can pay them.
Or not the
And he
order, but
will.
whether he can pay them?
Whether he can pay them or not. And you know the section, let me see if I could remember it out of my head, because I just had it here. When it comes to paying taxes, you know, that's the first thing that comes out.
Yeah.
Yeah, I'm trying to find it. No, not that. Why didn't I write these things? Huh? To what?
No, I was looking at, I say it shouldn't be 237 again, I guess.
I'm trying to find it right now. I just read it. Oh, come on. Oh, 237, yeah, preferential
Oh,
tax.
there's a- okay.
Mm-hmm. And the last one is, he wants your advice on it. He has a factory that has a 20-year lease on it. But that factory had to be shut down. It wasn't making any money. What should he do? Remember now, the liquidator, once he takes that position, he has to go and make sure that he has all of the assets of the company. And read also for this exam, make sure you read section 232, the effects of winding up. So you see, I did not make the exam hard. You agree? Do I have your agreement?
What's the word?
No, but I mean, I just said focus on
Yeah.
liquidation.
Yeah.
So you don't have to worry too much with regard to the midterm. It's two separate things. Now,
Mm.
because you all were so diligent, I have a 6th question. That 6th question is a bonus.
Mm.
6, 7, 8, 9, 10, 11. I give you 12 multiple choice.
Okay.
As a bonus.
So that was the
You
number
won't see the
6.
word bonus. You won't see the word bonus, but it's a bonus.
So,
Number
Ms.
6.
Doctor, okay.
Go ahead.
Oh, go on. I could wait till you finish.
Now just to say, so number 6 on the exam is the bonus.
Oh, okay.
Oh, okay.
So we still have to do this capstone.
Of course. Okay, hold on, let me pull it. Hold on, I have to pull it first. I had it here last night. And I was thinking how easy it was. I said, really should have changed it to something else.
We were so good. We were the only ones who left hanging. You should consider the capstone, you know?
No, you have to do a
Because-
capstone. But hold on. Let me get it. Oh, I have it here.
Pretend to sticking around.
Okay, so you have 4 questions, right? 5. Okay, so question 1, I know you all like that one. Correct?
Which one? For who?
For the capstone, the first one, human rights.
No,
Not really.
no, that
No?
was the worst one.
Oh, but I mean,
You
you
know-
all have already started it, right, or not?
So, yeah, something like
I did
that.
not start that one. I started
Not that
everything
one.
else. That was the worst question.
So you want that one off?
Please?
I wonder
Okay.
if this might be the easy one.
Of course, it is the easiest one, but y'all want it off.
You see?
The corporate human rights?
Yes, it is.
That
A
was
lot
an
of
easy
information on the
question.
internet on that.
Mhm. I wonder if we should keep that.
Well, up to you.
That was not the easiest question.
No?
The
Okay.
easiest was probably between number 2 and number 5.
So what happened to number 3?
Number 3 was a little tricky. I still need help going over that. 'Cause
I
I misunderstood it a couple of times.
I think number
I
3,
could-
you just want order of 1, 2, 3, 4. That's what you want, right?
Yeah, I could take that one off. It's on corporate insolvency.
No, we keep
No,
that
Keep
because
that?
that would be a good idea so we could know what we're looking forward to when we get to the exam.
Okay. So what about 5?
5 was easy. I like that.
Okay.
I appreciate that. It was still a little tricky because I ended up learning more on this private and public part that I did not know about originally.
Okay. And what about 4?
4 was tricky, but it was easier than number 1.
You still back to number
You
1?
think so?
Okay. Let me settle it for you. Do 4 out of 5,
We could choose today.
and you choose.
Oh, great.
That'd be better.
I mean, that's actually great. That's
You
actually
say
Okay.
3? You say 3?
Don't go there. No, because they're not really the longest one. I think you would have would be number 1. But
Yeah.
you determine that. I could read from the paper. If let's say your paper is really only 6 pages
Mhm.
and you have your bibliography at the back, I could read from the way in which you wrote to see how many companies you research and what you learned from it. You don't have to write no 20, 25 pages.
Okay.
This is very short and to the point.
Mhm.
You could easily
So what-
find 5 cases on the internet.
So what do you think about number 2?
Oh, number 2 is easy.
So you don't think that has a lot of wording to put in there? Yeah. That's the show. Okay.
Let's see. Let me read the last part again. He has a proposal. He declines,
That's the one I started to.
but finds himself faced with a proposal at an extraordinary meeting of the company. The company's articles be changed so that any member can be requested by the board to try. We did this.
I
You don't
think
remember
that-
this?
Yeah, I think so. I started to
this.
answer this.
Yeah.
Chart. Okay.
Mhm. We did that one. But I think number 1 is very easy. That's a good question.
It is a good question, but it does not mean it's easy.
Oh, you don't want to do no research. That's all. It's not that hard.
So when we're doing research for this number 1, if we decide to do it, we can get these cases on offline.
Yeah, they're
From
right
online?
online. Yes, right online.
So we could say we refer to this. We
Yeah,
have
you
to
just
make
put the
reference to say
links.
where we get it from.
You can just put the
Oh.
links.
Oh, okay, okay.
Yeah, put bibliography and we can put links. Put the links if you use.
Mm.
I know them all, so I know, so it doesn't matter. Like I say, once I read it, I will know if you've read it. Yeah, I will know. So do 4 out of 5. I think that should be because you're practically there now anyhow, right? Oh, reading
Yeah,
hard again.
me.
Why?
Because I only started 1 so far. 'Cause
That's
That's why.
2, 3, 4, 5. So what you want to do? 3 out of 5?
Do we have the majority?
3 out of 5, I mean, listen, this sounds like she's gonna ask us for more pages.
No,
Is that what you're
Right.
asking?
no, I did not say no such thing.
I'm making sure.
I didn't. What you mean for the first one? Or for all of
No.
them?
No, hang on. What was the vote? What was the vote? That we do what, 3 or 4 questions out of 5?
She said
Yes.
4. And she's
I
now
said
she's
4.
actually going to do 3.
How many of you completed?
I've not completed any.
How many of you started?
I only start 1.
3.
Right. You started 3. Okay. Blair, how many have you done?
Yes.
I started 3. Let me say I've done the outline and I just need to write now.
Okay. So which one is for time constraint and because you have to study for the final exam? Which one is better?
What you mean to X out or to?
No, you choose. You could choose.
Also, just choose one?
No. Listen,
Blair,
either
wait till-
4 out of 5 or 3 out of 5. Which one?
Oh, I'm always for the lesser of the 2
Well, it's-
evils.
Okay.
Yeah, well, we can go with the 3 out of, we could get 3 out of 5. You could still get them on the 4th of September, and we still have plenty of time to study for finals.
I say 3, because there's only 3 of us
3?
left.
Yeah,
Okay.
see?
All right. Okay. All right. So I've changed that. I have on top of my own 3 out of 5.
Okay.
Sasha,
So I
don't grade us
expect-
too hard. Don't do harder grade now, because we get 3.
Okay, Miss Archer, so we do 3 out of 5, right?
Yes.
If we decide to do a 4th, would you take that as an extra to add to our grade to help where we may need it?
Oh, okay. You can put it on your midterm.
What do you mean?
Really?
Add to
Add
the
it to your
mid.
midterm.
Oh,
Oh, so
I
if we do
I
the
need
4 out of 5 or more, then it'll add to what the midterm was?
Yes.
oh.
I'm not gonna promise you 5, so
No.
I look at this 4 out of 5 for sure.
Okay.
Okay.
That'd be great.
Yeah.
Okay,
I
so-
can add it to the midterm. I made a note.
Okay.
All right. So now we're back to 4 out of 5 or even 5 out of 5. I'm smiling.
So we can do 3, but we can do 4.
I
Yeah.
mean, she got a question to
The capstone requirement is 3.
Mhm.
If I see you write more than 3,
Yeah,
the difference goes towards the midterm.
okay.
That's how that'll be done. You bargained well.
I swear. I gotta go into 2.
You bargained well now. It's
I
done.
can need y'all in my next class. I take good tips.
So you what?
I can need the next one if I do company law too.
What
so
you
they
can need?
negotiate. The negotiators,
No, well, that's because there's only 3 of you. When
Exactly.
there's more, there's no negotiating.
No.
No. If we have the 12 people we started off with, you can imagine us trying to figure this out now. Mm-mm.
Oh.
It is what it is.
that's the class. Did
No, this is
everybody
free
do-
online. Others may take the exam.
Oh, okay.
Yeah.
Oh.
Others, there's some people just come and take the exam.
Okay.
They'll listen to what we discuss and then they will go and study and they'll come and take the exam. Don't think it's just the 3 of you now. Trust me, they come in.
Oh, okay.
They come in to take it. So
Okay, so where are we taking this again? I wanna make sure I know.
at Biff's,
Okay, so we come there physically, there's a space for us, especially with all
Yep,
the
yep.
regulations?
yeah, they have plenty rooms.
Oh, okay.
You all be the only ones there.
Okay, and what time?
I think it's 12, eh? Miguel will send you an email.
Okay.
Oh, okay,
He'll send you the email with the timing.
Brilliant.
Yeah, he'll send you. And you all will be spaced out. So some will be in one room and some will be in another room. So
Mm.
So send up a prayer for us.
I will, but the thing about it is I wrote these whereby the answers are not long. You're not writing no long speech. Probably the longest may be the corporate governance and enterprise risk management. But all the
Right.
other ones, as you can see, I broke them down in A, B, and C. They're very
Mhm.
short. They're very short. So I don't think you're gonna have any difficulties with those. And especially if you've read that whole section under where the liquidator now has to pay debts, you should know how to answer these questions. And I've already given you the scenarios, so I don't think it'll be that difficult for you. All right.
Okay.
All right. So study hard.
Are we
Why would
having
you-
any class next week or this is the last class?
This is the last one.
Okay, okay.
Yeah. So I'll
Just
do
feel-
now. I'll spend my weekend writing my capstone so you can focus on your exam. And then you'll find that it's so easy.
Okay,
It's been a pleasure, Ms. Archer.
You're most welcome.
thank you very
Yes.
much.
Thank you so much.
Okay, bargainers. calling you all the bargainers. That's the only thing I can call you all. Bargain,
hope-
bargain.
Hope to meet you in person one day.
Oh, yes, you probably will. I'm always around this. You'll see
You're
me.
not gonna be there to introduce us with this exam?
No,
Oh,
She
I
said,
get
y'all
that.
can get.
I just collect them. That's it.
okay.
Collect
I could be
afterwards.
passing you on the road and I know that's you.
That's all right. Don't worry. One of these days you will know, because then you may be somewhere and you may hear my name and you'll say, like one of my former students, he say, "Hi, teacher." I said, "Don't do that in public."
Oh,
So,
goodness.
no. So that's how.
All right.
Questions, however.
All right. Not a problem.
What's your time frame for answering so I know what I'm looking forward to?
Not on the day of the exam.
No.
So before I go
Otherwise,
to
it's
exam.
fine.
You might
Otherwise,
push it by
it's fine.
Thursday, that Thursday before though.
Yeah, you can send it. You can send it, but not on the
Okay.
day of the exam.
Okay.
All right.
Okay.
Okay.
Thanks, Ms.
So
Archer.
study, and you're most welcome. Go and study now.
All right.
Yes,
Okay.
ma'am.
All right. Bye-bye.
Bye-bye. Bye.
Bye.
Bye,
Bye.
everyone.